You're standing next to your mom when a drunk driver plows into her. She survives. You're physically fine, but you develop PTSD from watching it happen. Can you sue the drunk driver for your trauma? That answer depends on which state you're in, and it's absolutely ridiculous. Welcome to Negligent Infliction of Emotional Distress, the tort that proves our legal system has no idea how human psychology actually works. So unlike intentional infliction, where someone is trying to mess with your head, NIED is about accidents that cause psychological trauma. But here's the problem. The law treats your mind like it's somehow less real than your body. Let's start with the old school zone of danger rule. Basically, if you weren't personally at risk of physical harm, too bad for your mental health. So, if you watch a car hit your kid from the sidewalk, you can't recover. But if you were crossing the street with them and almost got hit yourself, now we're talking lawsuit. This made no sense to anyone with a functioning brain, so courts created the bystander recovery rule. But they made it so complicated, it's like they were trying to keep people from winning. You can recover if you're a close family member, but good luck if you're the step-parent who raised that kid, or the fiance who's been together for 10 years. The law loves biological relationships and hates chosen families. You have to be present at the scene, not 5 minutes later when you arrive, not watching it happen on security cameras later, right there, right then. And because apparently trauma has a statute of limitations measured in seconds. And here's my favorite requirement: contemporaneous observation. You have to see it happen. If you hear the crash and turn around to see the aftermath, that doesn't count. Your PTSD isn't valid because you experienced it through sound instead of sight. But wait, there's more. Many states require physical manifestation of your emotional distress. So your crippling anxiety and depression don't count unless you can prove headaches, stomach problems, or sleep disorders. And because apparently psychological suffering isn't real unless your body keeps score. Here's where it gets really weird though. There are these random exceptions where courts suddenly care about emotional harm. Funeral homes mixing up bodies, massive NIED verdicts. Doctors telling the wrong family their relative died, payday. Medical professionals mishandling corpse, ka-ching. Why? Because courts finally admit that some situations are so inherently traumatic that emotional distress is totally foreseeable. It's like they discovered empathy, but only for very specific scenarios. The mortuary industry is basically an NIED lawsuit factory. Cremating the wrong person, losing remains, families opening caskets to find strangers. This stuff happens more than you think, and courts actually award serious money because even judges understand that's psychologically devastating. But here's what's truly insane: the inconsistency. A mother watching her child get hit by a car might recover in California, but not in New York. And don't get me started on the close family requirement. Courts have literally said that grandparents who raise their grandchildren cannot recover because they're not immediate family. But biological parents who abandoned their kids years ago, they're golden. The modern trend is toward more recovery, but it's happening at a snail's pace. Some courts now allow recovery for witnessing injury to close friends, unmarried partners, and even people you just care deeply about. But most states are still stuck in the 1950s, pretending that trauma only affects nuclear families.